Nothing goes out. We treat that client as if it's a $450 an hour client. I wouldn't send a position letter out on a client's case without letting the client see it first. So that doesn't change. We email it to the client, they make any suggestions, or they say this is fine, and then they get it. Then we send it out on our letterhead, and they get an emailed copy of the letterhead back.
I bet you the clients are pretty responsive.
They're very responsive. They can't believe. Right.
I'm sure the turnaround time is pretty good when they get back to you.
Oh, absolutely.
They're not goofing around.
They're not goofing around. They're anxious to get this resolved.
Right.
They want to get the letter out. They want to make sure that it's accurate. You know, we're very careful that what we say is accurate.
There's one issue that I want to point out is when you send out that letter, it also stops Getty's attempts to collect. Would you like to elaborate on that?
Sure.
With the NCS situation?
Sure. Well, one of the things that Getty does, I mean, I know, and this is covered very thoroughly on your site, on our site.
Right.
They'll send a series of letters, and if it gets to a certain point and you can't meet their terms, they send it to NCS Recovery, which is a collection agency. Now, they call themselves a collection agency, and before we got involved, the letter used to say, we're going to put you into collection, and this is an attempt to collect the debt. We pointed out to them that they can't say that because it's not a debt, it's a claim.
And they understand that too.
They understand it, and now the NCS letters say this is an attempt to resolve a settlement, to achieve a settlement, or this is an attempt to resolve a claim. So similarly, the collection agency can't contact you any further.
Right.
Once they receive a lawyer's letter. So the other issue,
and they've been respectful. We should point that out.
Very
right?
respectful.
Well, we should point that out.
And I think we pointed this out on our website also.
Yes.
It's a professional company. Getty's a professional company.
Yeah.
The letters are well written. They know what they're talking about.
Yes.
What we disagree with is the tone of it, particularly when they first started. I'll talk about that a little bit later. But NCS and Getty have been very respectful and following the law. It's not only respectful, it's following the law.
Right.
In not contacting the clients directly and dealing just with us. And we've had, many letter exchanges with Getty. We've had phone conversations with their legal counsel. We're in communication with them over these cases, and we're trying to see if we can get them to recognize some of the flaws in their program. But in any event, one other little factor, it's a little nuance, which is anybody who's ever received a collection letter knows that one of the things it has to say under fair debt collection practices, anything you say, this is an attempt to collect the debt, anything you say may be used in a litigation to resolve this debt.
Right.
Okay.
What's the counterpoint?
The counterpoint is that once you are trying to do something in settlement, things that are said in settlement are not admissible in a court of law. So it's the exact opposite.
So you brought that up to their attention.
They are aware of that. But the point is, even folks who don't retain us have gained this benefit of our program. Now that NCS is saying it's an attempt to settle a claim and not collect a debt, that means whatever you say to them in writing or in oral communication,
can't be held against them.
Right. You can say, yeah, I had that image up for 6 months. They can't say that in court now. Where before, if it was an attempt to collect a debt and they notified you,
that is a very interesting point.
It's a little nuance.
Yes.
But it allows people now to speak a little more freer. I still wouldn't say anything that would be harmful to your case. That's never wise to do.
Right.
But when lawyers do it in settlement, it's understanding they know the ground rules. But so that's the benefit of the program that we've established that I think is kind of hard to grasp, but was very beneficial. The other thing is that Getty themselves have changed their position.
Yeah, go ahead and elaborate. It's like you're almost educating them, really.
No,
as
they
a
know.
Process. A little bit.
Right. I certainly don't think we need to educate them. They know the copyright law. This
But
is why- this is
they've
why-
adjusted themselves a little
Right.
bit.
Right, but that's also to the benefit of the client,
Yes.
because what happened was they started seeking statutory damages. They're not entitled to statutory damages. We pointed that out to them because they haven't registered these images with the Copyright Office. Then they talked about allowing them to get their legal fees and costs, because we kept writing and explaining to them, tell me why this stock image, which you, Getty, sell for $49, is now all of a sudden worth $1,200.
Yeah, they've never explained it. I've asked it, even before you were involved. You've asked it, and they've all but said there is no particular formula. See, it appears to be a computer-generated number.
They've changed their position on this.
Yeah, it's
Initially they
very
said it-
suspicious.
Right. Initially, they said it was because they're entitled to statutory damages. We wrote a letter that said they're not entitled to statutory damages. They said, you're right, we never said we were. We only give it as an example. It's our actual damages, but we also have to take into account our cost and recoup our costs to try to
Like
get
Pig
those.
Scout.
But, well, not really Pig Scout, because
What is it implied?
they mean the cost of their staff and the letter writers and
Yeah, they're college,
They're
the college
college
kids,
interns or
which
whatever.
we found out.
right. You did a great job though. If we found
Yeah,
the
we
ad-
uncovered that with the University of Washington.
right,
You know, that's where they're getting these people from.
right. So then they wrote back in response to that.
Yeah.
Then I wrote back to them and said, well, wait a minute. Since you did not register these images with the Copyright Office at the time of the infringement, you're not entitled to anything but your actual damages. You're not entitled to get your legal fees and your costs. So how could that be? Then we got another letter, a different letter, that said, well, you should be aware that very often courts in copyright matters give what's called multiplier damages. And we're asking for this money because we believe we're entitled to multiplier damages. Well, we found out two things about that. Well, first of all, I wrote them back and said, you're not entitled to multiplier damages. And I gave them case law that showed they weren't entitled to multiplier damages. But more importantly, Getty put out an internal memo to its photographers advising them that prior to giving it to Getty, they should copyright their photographs. And because if they don't, register their photographs, if they don't register their photographs, this is Getty's memo, we will not be able to get multiplier damages. So I wrote them and said, how can you write this memo and then write this letter? In this memo to your photographers, you say you're fully aware that you're not entitled to multiplier damages. And then in this letter to my clients, you're saying you're entitled to these damages. They wrote back and said, we didn't mean that either.
Well, it could
We're
be
just
two
giving you
different
an example.
departments, wouldn't you say? I mean, it's a big company. Do you think they consciously, or do you think the right arm didn't know what the left arm was doing?
I would hope that's not what it was, because a company that's taking this on needs to establish policy. Before you begin this kind of program, where you're writing thousands, it's not hundreds, thousands of letters to people, and making claims of damages, I would hope that there's been some internal review from your general counsel to know what your legal position is. So I have to believe that this comes from really nearly the top down. Maybe not the top, but nearly the top.
Yeah, but the implication the other way isn't good either. That means they're consciously saying this stuff intentionally. They know it's not true, but they're hoping the fear factor will get people moving. I mean, I don't think it paints them in a positive light the other way either.
It's not positive that way either. You're right. It could be in this particular example that the part of Getty that communicates with its photographers didn't know what the litigation arm was saying.
That's what I'm getting at. That would
Maybe.
be the less, I think
That's the
that's the
lesser
lesser of two evils.
It is definitely the lesser of two evils, and let's hope it is that.
Right.
What they claim is that I misunderstood their letter. And if you see the letters, I think we even posted them, there's really no misunderstanding of them.
Right.
But be it as it may, whatever it is, fine. They're off the multiplier claim. That's all we really care.
Right.
So we know they're up to actual damages. And now the fight is, what is the actual damage?